Welcome to another episode of The Breakdown. Oh boy, this is going to be a can't wait to see my Twitter replies kind of episode because there's some legal issues that are going on in the province of Alberta, and there's some legal issues that are going on across the country that the province of Alberta seems to be trying to insert itself into. It's all a big mess. We're talking about the notwithstanding clause. We're talking about mandatory minimums for child sexual abuse and exploitation material. So I'm going to throw this up right ahead, probably trigger warning. For all kinds of trauma talk for this entire episode, just to be, I don't want to surprise anyone. But there's been a lot of misinformation. There's been some disinformation. There's been some lies around all of these topics. And in order to try to sort through some of those, I'm very excited to welcome to the program. It's a lawyer. We got a lawyer on the show. Very excited to welcome Will Van Engen to the program. Will, thank you so much for joining us.
Thank you for having me.
So before we get into all of the very light material that we're gonna be talking about today, if you wouldn't mind, because like I looked at your bios in a couple of places. You've got a wild history. If you wouldn't mind talking a little bit about who is Will Van Engen, and I am going to ask you to talk about what did you do before the law stuffs, and how did you get into the law stuffs?
Yeah, so again, thanks, Nate. I appreciate you having me, and I'm glad to talk about some of this stuff today. I can tell you that I'm a criminal defense lawyer. I've been a criminal defense lawyer for about 10 years. I work at a law firm here that does criminal defense work exclusively. Prior to that, I worked in journalism. I was a freelance journalist. I wasn't an employee of any particular organization, but I did a bit of work overseas, did some work documenting human rights abuses and human rights issues in different parts of the world. And I did that for a couple of years, and then decided to transition and shift gears to something different, and got into law school, and found that I was really drawn to criminal defense because it involves some of the same issues, dealing with human rights issues, dealing with constitutional rights and freedoms. And so there was a natural transition for me to go from that world into criminal defense.
And this is something I want to flesh out a little bit because I think one of the things that people think of when they hear criminal defense lawyers is how do you sleep at night defending the scum of the earth? And there's probably an argument to be made for some of that. But I think another piece that's really critical for people to understand is the idea that if the system isn't followed properly, if the checks and balances and the rights aren't respected and followed, that's where really terrible things can happen. And there's a lot of nuance that happens in regards to how people find themselves in front of a criminal charge potentially. Can you talk a little bit about that piece?
Yeah, so criminal defense, and if you talk to any Crown prosecutor, they will tell you the same thing, that the defense is an essential part of the system. It's critical that people who come before the courts, who often don't have any understanding of how the system works, who are often out-resourced by the state, by the government, by the Crown Prosecutor's Office, it's important that they have somebody looking out for their interests. And we as a society take the view that the way to get to the truth in matters that go to trial, for instance, or the ways to get to the best outcome in terms of a sentence are to have two very strong parties, one party being the Crown prosecutor representing the state, and the defense lawyer representing the accused, coming together before an impartial and objective decision maker, providing their best arguments and letting the decision maker make the call. So it's critical in particular in trial matters because, more often than not, the police get the right person, but sometimes they don't, or sometimes the complaint, there's a false complaint. Sometimes people can get sidelined by charges. And so it's important that the defense be there to try and ensure that the innocent aren't convicted as well. Beyond that, it's also an element of, in my view, human dignity, showing every person, no matter what they've done or what they're accused of, showing them that decency and humanity of being there to defend them and represent them. We're not their mouthpiece. We don't engage in putting just anything before the court. We don't, we are ethically obliged not to mislead the court or mislead the crown. So we have to do everything we do ethically. But we're there to make sure that they get a fair shake.
And I think the other thing that I just want to kind of point out before we get into the big things is there are examples where mistakes do get made. I mean, there's certainly some famous examples of Canadians who have been wrongfully convicted and spent a great deal of time in jail because of that. But even recently in Alberta, we've seen a news story about somebody who was charged with a number of charges. One of those charges did end up sticking. I think it was for handgun possession. But the other ones were determined that there were very real concerns whether or not the evidence was reliable, I'll say, to keep myself out of trouble. So the function of a criminal defender is not just to defend the bad people. It's also to defend the integrity of the system. Is that a fair statement, do you think?
Yeah, I think that's a fair statement. And there are unfortunately way too many cases that we can talk about. Milgard being, of course, the most famous one, involving people who have spent many years in custody because even though they were innocent. I can tell you in my own experience and my own experience as a defense lawyer, I've had a number of cases where I'm very confident, with demonstrable objective proof that my client was innocent. There are many more cases where I believed my client was innocent. I didn't necessarily have the proof. But that's why the system is so important, and that's why the standard of proof beyond a reasonable doubt is so important to make sure that we don't convict the innocent.
Okay, perfect. So criminal lawyers aren't necessarily.
We're not so bad.
There we go. The reason why I wanted to talk to you today, one of the many, is because back at the beginning of November, when Bill 2 was rammed through the legislature, there was a group of criminal, and I found this fascinating because it was criminal lawyers. There was a group of 4 criminal law associations across the province who all said, "Whoa, whoa, 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 whoa! The notwithstanding clause, using it this way, this is a very, very bad idea." And I'm wondering, like, you're not a signatory to any of that letter, to be clear, but I found it fascinating that criminal lawyers were weighing in on the a union dispute with the teachers. And so I'm wondering if you can sort of flesh out what your understanding of what the concerns are.
Yeah. So, and to be clear, I'm a member of the Criminal Trial Lawyers Association, which is the organization of criminal defense lawyers in Edmonton and Northern Alberta. The letter was signed on to by the presidents of all 4 of the criminal defense lawyers associations in Alberta. I'm a member of the CTLA, and I was supportive of the letter. And what's important is that, and we framed the letter, the letter was framed in such a way that we're not weighing in necessarily on the merits of the labor dispute. That's not really within our wheelhouse. But what is within our wheelhouse certainly is the effect that a deprivation of rights can have on a particular group. And a lot of the work that we do as criminal defense lawyers are vindicating constitutional rights, defending people's constitutional rights in court. And so I believe our organization and the other organizations in Alberta felt that it was important for us to make very clear that we are opposed to this sort of use of the notwithstanding clause, and that it can cause real concerns. It was noted in that letter as well, another concern, which is that this, as we were talking in end of October, that the use of the notwithstanding clause with respect to the teachers could be a stepping stone to using it again for other people and other individuals and other vulnerable groups. And of course, we've just seen that with respect to Bill 9, that the government has invoked the notwithstanding clause yet again. And so I can't speak to the labor dispute with respect to the teachers. I can't speak to the merits and the details of the bills that address trans youth and trans women in sports. But I can certainly speak to and have concerns about the use of the notwithstanding clause and the manner in which it was used.
Okay. Um, let's talk about that a little bit. So, you know, today is the 14th. Or no, it's not the 14th today. Today's the 22nd. I don't know where I am. Alberta politics. Today's the 22nd. God willing, this will be going up on the 23rd. Today, Danielle Smith was asked on her radio show, Your Province, Your Premier, hey, you keep saying that Lougheed would be down with this. And Lougheed actually did a speech in 91 that later turned into a paper in 98 where he said, these are the criteria that I believe, with the benefit of hindsight, that the notwithstanding clause should be used in. And he was very, very clear it shouldn't be used preemptively. He was very, very clear he believed there should be a supermajority in the legislature. Both of those things are not the case today. And Daniel Smith responded by saying, well, yeah, but he said in the 80s that unions shouldn't strike, which is a fascinatingly limiting view of Lougheed to me because it suggests that the man was incapable of learning anything. I feel like that might be a little myopic, but what is what are your concerns with the way that the notwithstanding clause was used on Bill 2?
So, in relation to Bill 2 in particular, part of the concern was, as Lougheed pointed to, the preemptive use. So this wasn't a scenario in which the law, there was a dialogue between the courts and the legislature, where a law was passed, it was addressed by the court, and it was, for instance, struck down or read in a certain way that that the government and the elected officials thought ran counter to the public's view or the public's desire for a particular law. So there wasn't that back and forth, that time to consider, have the court weigh in, have the public think about it. If you're going to abrogate or remove someone's ability to challenge a law, in essence, depriving them of a constitutional remedy, depriving them of constitutional rights, it should be done in such a way, if it's done at all, in a way where there's a lot of time to think about it and consider it. And what happened with Bill 2 was it was put through a very quick, is my understanding, a very quick process on, I think it was October 27th, where the law was debated and considered and decided upon and voted upon in the course of a single evening, a late evening, but a single evening. If you may recall, that was game 3 of the Dodgers Blue Jays series, and there's the 18-inning game. And it went a little longer than that, but I don't think by much. And so, where is the ability for members of the Legislative Assembly to consult with their constituents, to think about this in more detail? It was put through very quickly. And I can appreciate in a labor dispute, time is of the essence, but in my view, when you're dealing with constitutional freedoms and rights, there has to be, I think, more consideration before the notwithstanding clause is used. And I think it's worth noting, in terms, you spoke about disinformation and misinformation. There are people talking about, that Section 33 is, that people are being in some way unlawfully deprived of their rights. To be clear, Section 33 does allow a legislature to specifically exclude a law from constitutional scrutiny. So that is one of the tools in a legislature's toolbox. The Supreme Court is going to weigh in on the scope of that in a case coming up shortly. So we'll see whether there are some guardrails to that. It is something they can do, a legislature, but we should be concerned when it's done in such a way, in a way like that's very quick, not thought through. It needs to be given some very serious thought as the members of the public.
I'm a big believer. One of the fascinating things I find about political communications is it seems like more often than not, the goal of political communications is to make only one thing be true. And it's the thing that we want to be true. And I'm a big believer that more than one thing could be true at the same time. So would it be safe to say, because you're putting some nuance into the conversation, and I'm here for that. Would it be safe to say that the invocation of Section 33 is an entirely legal way to rob someone of their charter rights?
That is correct. And that is why it has been considered the nuclear option for so many years. Because what you are saying when you're passing that law is either explicitly or implicitly, you're saying, I'm passing a law, or we are passing a law that is going to violate your constitutional rights, that is going to take away your constitutional rights. Again, it is lawful. It is part of our constitution. It allows for the legislature to have the final say, but it has serious consequences, and so it has to be considered very thoughtfully. And as you will probably know, it hasn't been used in Alberta. Prior to Bill 2, it had not been successfully invoked and implemented into a law in Alberta. Again, I'm not a constitutional historian, but my understanding is that it was referenced or brought up a couple of times during Ralph Klein's government during his tenure as premier. And it was discussed, and then it wasn't used. So this is the first and now the second within 3 weeks time that Alberta has used the law.
One of the things that I think is also interesting is it seems like there's this counter argument, and I'll get you to litigate it for me. But there's this counter argument that's taking place on social media that I want to address, where people are saying, "Oh, what rights are taken away?" And I mean, there's a list. With the teachers, there's the freedom of association, and certainly with the anti-trans stuffs, there's like a bunch in there. But I find it fascinating that argument is even being advanced because if there weren't any charter rights being taken away, then you wouldn't need to use the notwithstanding clause. So isn't its use a tacit admission that, oh no, we're taking away charter rights?
I think it is, and I think that's why, again, why it's previously been politically, politically damaging to use it, because we tend to value our constitutional rights and freedoms. And since 82, we've had the Charter of Rights and Freedoms. It has provided an ability, the ability for someone who has had their rights violated to seek a remedy in the court, to seek justice for that violation of their rights, and to challenge laws that are going to infringe the rights of many others. So in relation to Bill 2, what the government is doing is saying we are going to shield this law from a challenge by the unions or by teachers individually, a challenge that says this law violates my right to freedom of assembly, freedom of conscience, freedom of speech, and so on. They've included in both of these. I have not had a chance to read the text of Bill 9 yet, but Bill 2 does explicitly reference a host of other sections of the charter, which it seems unusual that they would include those because they don't seem to be relevant, but they're removing challenge for equality rights, search and seizure rights, life, liberty, and security of person, a host of legal rights. So, and they've also indicated the Alberta Bill of Rights and the Human Rights Act as well are, you can't challenge it under any of those either pieces of legislation or parts of the Constitution. So it is saying we're going to impose this law, which is going to potentially have these effects on your rights, and we are going to stop you from challenging it.
And I find like I don't like to be entertained by this, to be clear, but there is a part of me that does find an irony in the rank hypocrisy, I guess, of the inclusion of the Alberta Bill of Rights, because they just went back and messed with that a whole bunch. Literally, Danielle Smith's government is the first government in recent memory to go back and make a bunch of changes to appease the base to make sure that the freedoms were never impinged on again because COVID. And they're having to now say, oh yeah, that those laws that we updated and everything, we're gonna ignore those too. That to me is particularly telling because there's that adversarial relationship that happens between the provinces and the federal government, and everybody likes to complain about the charter and how we should change it, and that'll never happen. But the fact that they had to go supersede their own recently updated legislation is to me profoundly telling. Am I missing anything there?
So I would say I find it particularly unusual that a party that considers itself a conservative party would be so prepared to pass laws that violate constitutional freedoms. Conservatives, in theory, are small government types. They're people that believe in that society is better when we have a smaller government. And what rights do is shield you from the government. That's what rights do. So constitutional freedoms do. They shield you and protect you from government overreach. So it does strike me as unusual that they would do this. I think it's also worth noting that the government, when these cases are litigated, and the laws with respect to the ability of trans youth to access puberty blockers and for surgeries under 18, those laws, of course, as you'll probably know, have been challenged, if I'm not mistaken, by some LGBTQ plus groups, as well as the Canadian Medical Association. So there is litigation that was ongoing, and there had been an injunction that had stopped it from going into effect, pending a full hearing of the law. But what the government can do is, even if a court says this law violates these at a full hearing with all of the evidence and everything, even if a court says, yeah, look, this law violates the rights of trans youth under these various sections of the charter, the government still has the ability under Section 1 of the charter to justify that deprivation of rights. And we do have that happen in the courts. It's not unusual for laws to be found to violate laws, but there's some other overwhelming social good that comes from that for whatever reason. So that although this law might violate the rights of trans youth, the government be free to say, well, here's all this, I don't know if there's this medical data, but you could say there's this medical evidence that says this is, why we need this law, right? So that can all be litigated, and that evidence can be heard, and the government can argue that for whatever reason this is justified. And again, I can't speak to the merits of the law, but that is an option that the government has. I'm just not sure why they don't go through that process, and then you can justify it, and you can argue before the court and have the court say, yeah, the court may say, yeah, that's, even though there's this deprivation of rights, yeah, you've shown us that there's this law, that there's this evidence that shows this could harm these kids, and you can argue that.
I think there's a lot of people, and I would definitely be one of them, who would make the argument that they haven't done that because the evidence doesn't exist and because they just don't want to. Danielle Smith has said as much herself, that she didn't want to wait for the court process to go through. So it is, and this gets into where I want to go next, because the Premier of Alberta is showing open contempt for the courts in a variety of different ways. Certainly, I would make the argument that not allowing the court process to go through on a case where there has been an injunction issued because a judge did determine that there would be irreparable harm to those affected, and that there's such a small number of people who are affected that the balance of society is not, they'll be fine. Everybody else will be fine. There's, as you pointed out, there's ongoing litigation going there. So the fact that she would just step in and say, despite the fact that this hasn't been heard by the courts, I know better. That is, I think, a pretty strong definition of contempt of court, or the courts. But she's also taken it a step farther, because we've seen a new piece of rhetoric added to Danielle Smith's quiver. And that is the activist courts. The activist courts are doing all of these things, and we saw this play out on, appropriately enough, because if we're going to do horrifying things, let's do them on Halloween. On October 31st, she issued a statement by tweet, as we do government policy in Alberta now, where she called on the federal government to utilize the notwithstanding clause on a court case that had to do with child sexual abuse material. And there's no, I want to try to handle this as delicately as we possibly can, while at the same time, I'm not going to hold back on condemning anybody who is producing or accessing any sort of that material. I'll go on the record at the front end of this conversation and say I think that the sentences should be higher. I think the maximum is 14 years. I could be wrong, but I think that there's plenty of room to say if you have a demonstrated history of this sort of thing, see ya. I don't have a problem with that. But the court case had to do with mandatory minimums. So at this point, I'm going to hand it over to you. And if you can, to the best of your abilities, articulate what was that court case about? And then we'll talk about the mandatory minimums piece.
Absolutely, yeah. So that case is called it's Quebec and Seneville, and it was a recent case from the Supreme Court. And they say in a large portion of the decision, it's a majority decision, it's a 5-4 split decision. But they say effectively what you've just said, that this is a horrific crime, that it often will require serious punishment. And that's something that's been missing from how this case has been discussed. It is not the Supreme Court endorsing in any way or suggesting that child pornography use or possession or child sexual abuse material possession is not serious. They say repeatedly through the decision, the majority that is, and the minority decision or the dissenting opinion, they say repeatedly that this is a terrible crime and that possession of this material is something that ought to be punished appropriately. And that comes on the back as well of a number of other decisions that have come out in recent years, including a case called Friesen from 2020, where, and that's a pretty important decision. And it said essentially that in sentencing offenders for offenses against children, the sentences need to increase. So this is not a Supreme Court that is, light on punishment for individuals charged with or convicted of offenses against children. They've said these sentences need to increase. So that, I think, has been missing from the discussion. What this case was ultimately about was whether a one-size-fits-all mandatory minimum should, or whether that violates the rights under Section 12 to be free from cruel and unusual punishment or treatment. And what that section of the Charter does is it addresses cases in which punishments are grossly disproportionate. So where punishments are grossly disproportionate, the court can intervene and say that that law is no longer in force and effect. In this particular case, there were two individuals who had, I think one had 300 and some, one had 500 and some images of child sexual abuse material. At the trial level, the sentencing judge had indicated or expressed that the sentence should be lower. It should be 90 days for the one and 9 months for the other, and found that the mandatory minimum did not apply. At the Court of Appeal of Quebec, they upheld the ruling that the law violated Section 12 and that the law was not in force and effect. They upped the sentence for the one guy from 90 days to 1 year, and they did not disturb or change the sentence of 9 months for the other individual. So on appeal to the Supreme Court of Canada specifically, there was no, it was not argued or not brought up what the appropriate sentence for those two individuals should be. So that was not the focus of the decision. The court specifically references that the Crown, the Crown prosecutor that was appealing this decision was not appealing the specific sentences. They were only appealing the decision of whether the mandatory minimum was constitutional. And so the case was entirely about, does this one size fits all 1 year sentence, is that appropriate? And the mechanism they use when they're addressing these is to assess whether the sentence for this particular person who's before the court is a sentence that is grossly disproportionate or not, and also whether a reasonable hypothetical or reasonably foreseeable other offender, whether that would violate their rights. So, and the reason for that is to avoid, repeated litigation of the constitutionality of a section. You can bring up reasonable, not far-fetched, but reasonable hypotheticals that might come before the court to say, this particular law should not be in force and effect because a reasonable offender could become before the court, someone that we might see come before the court this would violate their rights. So we shouldn't have this law in the books anymore. So in this particular case, they considered the one hypothetical that they really focused on was a hypothetical of an 18-year-old offender, so someone who is just past, they're just 18, and they receive a text message from a friend of theirs who's dating a 17-year-old, and the 17-year-old or the friend sends a nude picture of their 17-year-old girlfriend. Okay, and the 18-year-old offender receives it, takes a look at it, and doesn't get rid of it. Okay, so in that case, because the images of somebody is someone, it's a sexual image of someone under the age of 18, it is child pornography. And that individual, that 18-year-old, would be subject to 1 year incarceration.
Mandatory.
So mandatory. So what the Supreme Court said is this is not far-fetched. You could see this happening, people sending nude images or sending text messages. Young people are often on social media, are often communicating with each other electronically. This could come up again. And so in that particular case, our view is that the majority, that is, that as bad as that might be, and it's not saying that conduct shouldn't be punished in some way, but that individual who receives that image should not likely be subject to 1 year incarceration. So that's what the Supreme Court was dealing with. They weren't opining on, in fact, they were opining on the severity of the offense. They said the offense is serious, but what they're dealing with is, does that 1 year make sense for those reasonable hypotheticals? I can tell you that in most cases, someone possessing, a moderate number of those kinds of images is likely going to face the 1 year sentence anyway. So this doesn't mean that people aren't going to get custody. It just means that in those cases where it really doesn't make sense to give them 1 year, the trial courts and sentencing courts are not constrained and forced to give them 1 year.
And I want to be just to be crystal clear, the way that the law is written, it doesn't even have to be the friend of a friend. If an 18-year-old is dating a 17-year-old and they're having intimate relations on the regular, so all of the things, and that 17-year-old sends the 18-year-old a picture, that would get captured within this mandatory minimums piece. Is that correct?
So it may not. That's not entirely clear. There is something called the private use exception, which says that if there's people who are close in age and there's images that are created or produced, usually the exception typically relates to people who are creating images together or something like that. If that is in that case and it's kept privately only by the parties, there may be a defense called the private use exception. So it may come into play, but the contours of that are, there's been a lot of litigation about that, but it would depend on the facts of the case whether that private use exception would come into play.
Okay. And the other piece that I think is important to highlight is this can get complicated really quickly with that mandatory minimum, especially when you start to look at what the minimum ages are for marriage. Because in the province of Alberta, a 16-year-old with a parental approval can get married. And so it's not inconceivable where a married couple sends some pictures, and those would constitute. And I mean, I think there's a very reasonable and nuanced conversation to be had of whether or not we should be having people married at 16. My answer would be no. But there's a very real conversation to be had if a 16-year-old who's married to a 20-year-old they're married sends that picture to their husband, and that husband then sends that picture of his wife to somebody else or whatever. All of those people are now captured inside of that mandatory minimum. And I think that you make a very important point in that if it's one picture that is shared, it's still not, it's bad, to be clear. And I don't think that anybody should have any sort of, regardless of their age, I don't think anybody should have any nude photos of them shown to anybody without their explicit consent. And given that they have the capacity and age to, I'm having to throw all the caveats in here because I can hear the Twitter trolls already. And given that they're of the age where they can consent to having that image shared, in the absence of that, to me, it's a no-brainer that it should be of varying degrees of criminality to be showing images of people who are not consenting to have their image shown um, to the audience that it's being shown to. Um, but I think it's really important to highlight that there is some degrees of severity. There's a huge difference between somebody who's sitting at home with a hard drive full of thousands of horrifying pictures and somebody who decided to send a picture of their wife or their girlfriend to a friend. They're very bad. Both of them are bad. I want to be really clear
Yeah.
about that. But the severity of bad is the difference between um, do we send someone to jail for a year with that mandatory minimum, or is there a better way to deal with this? And I'd love to get what your thoughts are. How did I do with all of that?
Yeah, so yeah, no, you're quite right that so I mean I think it's important always to reiterate that I'm not saying, and I don't think you're saying, you're clearly not saying that something like the hypothetical in that case where the 18-year-old receives that intimate image from his friend of a 17-year-old, keeping and possessing that and not immediately getting rid of that, because they shouldn't be seeing it, that's certainly conduct that would be captured by the criminal law. It is conduct that would be subject to punishment and worthy of punishment. But going from going to a full year incarceration with all of the effects that can have, that 1 year is going to make sense for a lot of people that are captured by this law, probably most, but it's going to potentially affect negatively and unfairly certain people who really aren't, again, like you've described, that ilk of people that are possessing quantities of child pornography on their computer or child sexual assault material on their computer. And again, the private use exception does hear some of those issues where you have, a close in age couple, let's say they're married and they take some images of themselves together doing, engaging sexually, that may be captured by the private use exception. So they wouldn't be penalized for that. But you could see other conduct like, again, that the person who's married sending the image to somebody else. And that can also be other offenses. There's an offense of sending intimate images. So a boyfriend sending without permission an image to somebody else of their girlfriend, adult or not, an intimate image, even if they're in their 20s, for instance, that's a separate crime. But if they were to send it of an image of somebody under the age of 18, then you're into child pornography. And again, it's criminal conduct, but is it conduct that is deserving of a year in custody? And what the Supreme Court of Canada is saying is, in those unique situations, that's going to be grossly disproportionate to the crime.
Thank you. And that's the piece that I think has been missing, and that's where I go back to. I'm going to loop back to the language that the Premier of the province has been using, because she's framing the court saying, "Hey, we should have higher penalties for these things. We should be making sure that we are dealing appropriately with these things, but that also means that we should be making sure that we're dealing appropriately with these things." It is not an endorsement to have child sexual abuse material. It is not permission to have child sexual abuse material. If you have that, you're still breaking the law. And depending on the degree to which you have that should determine the punishment and, God willing, the opportunity for rehabilitation if it's possible. But again, that's where the range piece gets to be so critically important. And for the Premier of the province to not acknowledge, hey, if people are saying, well, judges don't want to give the maximums because the maximums are 14 years, I believe. If judges don't want to give the maximums, cool. Let's make the maximums 28 years. Let's make the maximums 50 to 4 years, as I try to do math in my head badly. 56 years. So that we can make sure that when we have not that dumb situation that we just described, which is a dumb situation, that when it is something that is deleteriously bad, that person goes away for an appropriate amount of time. I know I'm comfortable. You know, I've read a little bit about the case myself, and I'm looking at the sentences that those two individuals got and going, I'm not cool with that. I feel like it should have been much longer. But that's not what the question is about. The question is, do the mandatory minimums are they appropriate? And so I think it's possible, and it should be possible for to say again, holding two things to be true at the same time. It should be possible to say, I don't know that the mandatory minimums, the way that they're structured, are going to be in the best interests of everybody at all times. I also think that these guys should have gotten way longer sentences than they did. Those two things should be able to be held at the same time to be true, but it seems like that's a reach too far for the province. Um, do you have concerns about the language that is being used by the premier right now? Because she misrepresented. I don't think it's a misread. I'll say it so you don't have to, because I don't want to get you in trouble, and I just do trouble. I don't think it's a misread of the situation to say that the premier has either deliberately or repeatedly accidentally misrepresented what that case was about for political means. And I don't think it's an accident that she's referring to the activist courts now. Um, do you think that there's a very real concern when governments start to delegitimize the courts?
I think that's quite right. And so I'm aware of some comments she made in the legislature regarding the Supreme Court, either, I can't remember the language she used, but endorse or affirming something like the right to possess child pornography. I mean, nothing could be further from the truth.
Premier. Thank you, Mr. Speaker. It was the court who basically affirmed a right to possess child porn.
I haven't seen all of her public statements about this, but there's certainly been a suggestion that the court here is okay with possession of child pornography, or that the court doesn't think it's serious, and that these courts are out of touch. And that is not what the Supreme Court case, the majority decision, that doesn't say that these are insignificant offenses. They devote quite a bit of the decision to talking about how serious and how harmful possession of child sexual abuse material can be and is. It's harmful to the children who are depicted. It creates a market and fuels a market for more production of that abuse material. It has all sorts of harmful effects. In fact, I'm forgetting exactly the language they used, but in a recent case, they talked about how offenses involving children are some of the most morally repugnant and horrific crimes that can be committed. And so this is not a court that is not taking this seriously. You can disagree with the way sentencing judges impose sentences. But what is being said about the Supreme Court decision is a misread or a misrepresentation of what the decision says. So I think that I have to believe that the people that are making these comments, the elected officials who are making these comments, know what the decision says. I hope they know what the decision says. They're either misreading it on purpose or misrepresenting it on purpose for political gain, or they're not reading the case. But I have to think it's the former.
I love your optimism. Because to me, it boils down to there's two choices. It really is somewhat binary. Excuse me. Either they haven't read the cases and they feel that it's appropriate to pontificate on them, in which case it makes them incompetent, or they're deliberately misrepresenting the cases for political gain. And this brings me to another point that I want to make sure that I absolutely hit on before we move on to the additional uses of the notwithstanding clause on the trans stuff. I think it has to be acknowledged that weaponizing the courts in this way and weaponizing the decisions of the courts in this way and misrepresenting what's being said is using the victims of child pornography and child sexual abuse material for their own gain. That is a thing that is happening. And again, I'm not going to ask you to, if you want to, jump on in, but if not, that's okay. To me, I have seen significant commentary online that has no awareness of the fact that manipulating these circumstances, either through ignorance or deliberately, is re-victimizing the people and using the people who have been the victims of these horrific crimes. And if that does not give people, if that simple fact alone doesn't give people pause before they just start spouting bullshit, that to me is a huge problem. And when the concern that I have that I want you to make me feel better about is we have a government, we have a premier who is either willfully or ignorantly misrepresenting what these courts are doing. She says she's doing it in the name of protecting the kids, but she doesn't seem to have any regard for the fact that she's using the abuse of these children to further her political gains one way or the other. And that, to me, is perhaps the strongest argument for why we need to have courts that have integrity, because politicians are clearly going to politician, and that scares me.
One of the concerns that I have about a number of these comments is it undermines the courts play an essential role in our democracy. They provide a check on the government, the executive and the legislative branch. They provide a review of laws to determine whether they are constitutional. They're an important piece of our democracy. And they are unelected, and that's by design, so they can make difficult decisions. So when the premier goes out and says that these are activist judges, or when she says that they're affirming the right to possess child pornography, and to be clear, I think she knows better. I think she knows that this is not what the decision said. There's no way, there's no reading of that decision which says they're affirming any right to possess that material. And to the contrary, as I've said a couple of times, they repeatedly throughout the decision talk about the severity of this material. And they've said that in numerous decisions in recent years of how awful this kind of material is and how awful crimes against children are. So she knows better, and other members of the government have done the same thing. And what they're doing is they're trying to undermine respect. They're undermining respect for the courts, which makes it easier potentially to usurp the power of the courts by using the notwithstanding clause. If you convince people that the notwithstanding, or that the courts are out of touch, then the notwithstanding clause is a lot easier to use. And so you shield all of your legislation from scrutiny. So that is, I think, the most significant harm. And the other thing too is that judges do not comment publicly or respond publicly to their criticisms of their decisions. It is rare that the Supreme Court even makes comments on decisions or laws, because they're meant to be objective, they're meant to be impartial. And so, when a sentencing judge, say, makes a decision and it's lambasted in the public sphere, and there's nothing wrong with that. We have every right to talk about decisions. That's why courts are open, so that the public can see what is being done and they can speak about it, and they can say, I don't think that sentence was appropriate, that was wrong. But judges can't respond or can't defend themselves. And so when, someone says they're affirming the right to possess child pornography, the court can't jump in and say, that's not what we meant. We didn't say that. And so it's sort of, you're attacking a branch of government that really can't defend itself in that sense. So I think that is the biggest concern I have, is that it is actively undermining faith in the courts. Courts aren't perfect. Judges don't make perfect decisions. It's a human institution. There's reason to be, reasonable people can disagree with the sentence that was imposed in that case, particularly the 1 year and 90 day, the 1 year and the 9 months that was imposed in that case out of Quebec. The courts have the benefit of having seen all the evidence, of having heard witnesses, of having learned about the background of the person. So they are in a good position to understand why that sentence may or may not be appropriate, but courts make mistakes. And that's why we have appeal for, and that's why we have public scrutiny as well. So it's fair to say judges don't always get it right, but it is unfair to say that there is some broader active, agenda on the courts to, be light on crime or not to be tough on crime.
And when we're talking about, I'm going to editorialize for a second here, but when we're talking about the fallibility of institutions, um, I feel like if a judge was to have been found to be in breach of one of the guiding rules for how they judge, they wouldn't be judging anymore. Um, of course courts makes mistakes, of course judges makes mistakes. And I think that the appeal piece is so important. The notwithstanding clause use removes that room for appeal, and when the notwithstanding clause is being deployed by somebody who's already been found by the ethics commissioner to be have breached the code of conduct, the ethics laws for her position, um Danielle Smith was found to have done that, for the record, for any listeners who are unfamiliar. Um, I think that that speaks to which group is going to be more fallible. Is it going to be the group that is responsible for appeasing the people who are going to determine their fates, or is it going to be the people who are there who are not? Judges don't. They're not there to win popularity contests. Politicians are there to win popularity contests, and we have a premier who's demonstrated that she will say and do just about anything so that she can always win the popularity contest. And I don't trust her as much as I trust a judge. And I'm not saying that I trust all judges, because I've had some experiences there too. But there's my rant on that. I know that we've got a little bit of a time deadline with you, so I want to be respectful of your time. But I also want to ask, what are the things that you would like to see? How do we? There's a word that I want to use that I can't use. How do we undamage? The other word starts with not the letter D. How do we undamage the situation? Because it seems like we're going down a road as a province where this sort of rhetoric is being embraced more and more and more. The demonification of the guardrails, the safeguards that are supposed to exist to make sure that one sole source of power can't screw everything up for everybody. How do we undamage this?
Yeah, it's a good question. I think uniquely with the Section 33, with the invocation of Section 33 in the notwithstanding clause, unless the Supreme Court tells us something a little different in the case that's going up about the contours of Section 33, the only real remedy is public outcry, public opposition, civil society speaking up about their concerns, which is what our organization did, and many others have done. And ultimately, it's something that has to be addressed, I think, at the polls, because there is, to my knowledge, and again, unless the Supreme Court says anything different, it is difficult to challenge the invocation of Section 33 in the courts, because it does exist as this tool for the legislatures to use. So I think people who are concerned about this need to speak up wherever they are in the political spectrum. I would like to think that conservatives as well would have issues with this, the use of the notwithstanding clause, because if it becomes normalized and it becomes used routinely, then it may come back around and may be used again by a different government in a way that people who might be, if you're supportive of putting the teachers back to work, if you're supportive of the laws with respect to trans youth, if you're supportive of those laws, you should still be concerned about the way in which it was implemented. Because if you're implementing these in a way that basically the government can, whenever it wants, shield laws from review, that may come around and affect you in a way that affects your own rights. There may be something that you're concerned about and you feel like your rights have been taken away or could be taken away. And another government may say, well, we're just going to put the notwithstanding clause in place, and we're going to stop you from having any ability to challenge that. So I think people need to be up in arms about this. Not literally, of course, but people need to be upset about this. and expressed that to their members of the Legislative Assembly, to their friends, to their family, and so on. There was reference in 2022 that Doug Ford had considered bringing the notwithstanding clause in to address a labor dispute as well. And my understanding is that basically public opposition was so loud that he backed down. I don't know all the details of how that went, but I think that that's really the only way that we can push back against this is through public and peaceful opposition.
And you bring up, you use the conservative word again there. And I would argue perhaps that one of the reasons why we're seeing some of the initiatives that we're seeing in the province right now are because there are a great many of Albertans who historically would identify as conservatives, who are looking at what is happening, going, I'm a rule of law conservative, and we just, I mean, technically followed the law by invoking Section 33 to take away, but we didn't do it the right way, and maybe we should have done it the right way. I think that piece is important, but I love we're seeing the sort of like, oh, you put the gun out in the middle of the field and somebody other than you went and picked it up, because we're seeing all of the recalls popping out across the province, and I have my own thoughts on those for sure. But it's not. Here's my question. This is a little hyperbolic, and then I'll let you have the mic for whatever else you want to add to the conversation. But in a province where the UCP put forward this recall legislation and the referendum legislation, and then lowered the bar to make it so that it's very, very easy to accomplish these things, in a turn of events that shocked apparently nobody except for the people who wrote that law, which is baffling to me. People used it. And I would make the argument that the responsibility of any government, anytime that they're creating new law, is to do exactly what you said, which is to look at, okay, so like, this is how we want to do the thing, but in the worst case scenario, how does this get weaponized? If you're going to create a nuclear bomb, you have to be prepared for the fact that if you use it, somebody else will too. And I find myself going to the thought experiment of, let's say that the NDP get elected. I'm not suggesting that this is a policy position of the NDP. To be clear, I'm not an NDP member. I don't know anything about that. But anyway, the super progressive party gets elected. I won't put it on the NDP, so I don't have to deal with those DMs. But let's say one day the super progressive party gets elected, and they decide to say, you know what? We like this idea with the notwithstanding clause that you put forward there, Danny. We're going to make it illegal for anybody to affiliate under the banner of conservatism in the province of Alberta, and we're invoking the notwithstanding clause to do it. That's a thing that could happen. Am I wrong?
So the notwithstanding clause, and of course, we're talking about a hypothetical scenario.
And I'm not advocating for anybody to do that.
I know. So I mean, it is, as you said, it's an extreme example. But a government could do something like that, and again, subject to what the Supreme Court that later says, we might have a different lay of the land in some months from now. But subject to what the Supreme Court says, there's nothing that stops, to my knowledge, a government from creating a law such as that. Which would be obviously very clearly a violation of freedom of speech, freedom of expression, freedom of assembly, it violate all sorts of rights. And you put the notwithstanding clause in there, and now it's shielded from scrutiny. And there really is no remedy other than you vote that government out, which is a remedy that can take some time. It might be some years before another election comes. So yeah, that is the concern with the use of the notwithstanding clause. There are probably, and there are likely situations in which the notwithstanding clause may make some sense, but again, it's hard for me to think of what that might be. But putting it through in a way that where there's very little scrutiny, very little oversight, very little discussion is concerning, and should be concerning to everybody.
Is there anything else you want people to hear? Is there anything else you want people to say? No. Is there anything you want to say to people? This week, it's just been such a week. The mic is yours for the last 5 minutes, is what I'm trying to say, sir.
No, I appreciate that, and I think I've said what I've wanted to say, and I appreciate the questions you've asked. I think people need to. I would encourage people to give some serious thought to how something like the routine use of the notwithstanding clause could affect them in the future. And even if they, for whatever reason, agree with the way it's been used so far, they should be concerned about how it might be used in the future in a way that would hurt them. And we're very blessed in Canada to have the the Charter of Rights and Freedoms. We're very fortunate to have those democratic rights and those constitutional rights, and it ensures all of us can, lead a free and meaningful life. So whenever we get into, or whenever governments get into abrogating or limiting those rights, it's worth paying attention and worth being concerned about.
Awesome. Thank you so much for taking the time to chat today. I really appreciate it.
Thank you. I appreciate you having me.
And that's it for another episode of The Breakdown. As always, if you appreciate the kind of content that we're trying to produce here, we would love nothing more than if you thought about signing up to be one of our Patreon sponsors at www.patreon.com/thebreakdownab, where for just the price of a fancy cup of coffee a month, you can help us continue to produce this kind of content. Whether you're listening to the audio version of the podcast, in which case maybe leave a review and a rating, or whether you're watching it on one of our streaming platforms, we want to say a big thank you to everybody who is part of the Breakdown's audience. And as always, take care of each other and keep the conversation going.